welcome everybody. Very good to see you all. My name, for those of you who don't know me, is Richard Schofield. I'm the Chief Planning Inspector at PINS, and I'm joined today by David Smith, who, as you may have seen in our marketing blurb, is one of our longest serving and most senior inspectors, and whether or not he likes it has been something of a mentor to me over many years, and I'd say is hugely experienced, very nice bloke, and will know an awful lot more about Greenbelt than many of you, I suspect. We will we've got about an hour. David will be leading the presentation. I may chip in from time to time, unless he pushes me out of the way. David's presentation will last about 35 minutes. There'll be time for questions at the end. As with previous webinars, for those of you who've come, there is the Q&A function, which we will be using. It should be at the top of your screen. So feel free to drop questions into that. We won't be taking verbal questions. So if you drop questions into the chat and then use the upvoting arrows, which are at the top right-hand side in the Q&A function, we'll at the end answer the questions that are, well, prioritize answering those questions that are highest up the league table, if you like, and we will generally avoid responding in the text, so that those who are watching can benefit from our sort of verbal responses on catch up. So apologies if your question doesn't get answered, but anything significant we'll try and address either, but perhaps afterwards if necessary. So yes, this is the third of our webinars, which have been extremely popular, which is very gratifying. They are a new departure for us. So as I say, forgive us if they're not hugely slick. Both David and I are coming to you from our home offices in different parts of the country, and we have our excellent colleagues from our communications team helping behind the scenes. So if we were nervous about the first of our two webinars, we're particularly nervous about this one because we'll be talking about green belts, which, as you are well aware, is often an extremely contentious topic. And more than that, we're going to be talking about the approach that inspectors are trained to take when dealing with appeals in the green belt. Obviously, that can range from anything from a small extension to a large housing or commercial development. I should say, if you've come along today hoping to learn how to win appeals in the Greenbelt, then you're probably going to be disappointed. We're really going to rather say something about, the approach that's recommended to inspectors, and to look at a few different types of development and how that's considered. What we are not going to cover is any kind of critique or review of national planning policy. I'm sure that won't come as a galloping surprise to any of you. That includes recent changes in relation to grey belt and other matters. So our job as inspectors is to interpret and apply national policy. It's not really to make or comment upon it. And we won't obviously making any comment on current appeal cases in the green belt or assessment of the merits of any previously decided cases. So please bear that in mind with your questions. We'll be talking about general principles and approaches rather than specifics. For those of you who are experienced in this kind of work, we hope it will still be instructive nonetheless. Just as a caveat to that, I should say that for those of you from the local government persuasion, the Planning Advisory Service, with whom we work closely on a number of things, have various events coming up. I think there's one on the 18th of February on the grey and green belt. So we won't be duplicating the content of that. I should also stress, because this does come up from time to time, particularly in the context of this, and indeed given recent government policy position and statements on greenbelt and other issues, inspectors, we do not receive additional briefings or steers from ministers or indeed other colleagues at MHCLG. We have the same material as everybody else, plus evidence and submissions that relate to our case. As many of you are aware, we have an inspector training manual, but that provides guidance about the approach to be taken, not how cases should be decided. We do, as a result of that, have our own quality assurance processes in place internally to make sure that we pick up instances of unsatisfactory practice. So please don't take anything from this webinar and use it as evidence against us. It's meant to be of help to you rather than a stick to beat us with. David will be making reference to case law, but again, please remember, neither of us are barristers or judges, although we do have inspectors who are both. So please do review any cases referred to yourselves if you wish to use them. We generally, in PINS, one of my teams analyses relevant judgments to see what lessons can be learned from them for wider practice and ensure that inspectors are aware of those. So clearly our view is not necessarily decisive in subsequent challenge. And one of the slides does contain references to all the case law that David will refer to, so you will have access to that at the end. So that's all I'm going to say for now. I'm sure you'll be pleased to know. I will hand over to David to kick off, but I will, as I say, probably chip in with questions and or comments throughout. So over to you, sir.
Okay. Good morning, everybody, and thank you, Rich, for the introduction that you gave me earlier. Just to say, yes, I've been inspector a very long time. I've done Section 78 appeals. I've done local plan examinations. I've been a manager, a trainer, and fairly recently I was professional lead for appeals. That's no longer my role. I'm dealing with the delights of written reps appeals. I've done quite a few of those in the Green Belt. So what are we going to cover today? So we've got two main sections, if you like. Firstly, we're going to be looking at the general structure of decision making. And then under that heading, I'm going to be thinking about the 6 steps, which I'll explain in a bit more detail in a moment, issues around inappropriate development, issues around openness, other considerations, and then some thoughts about very special circumstances. So that's sort of general overview, if you like, of decision making in the Green Belt. And then more specifically, I'm going to look at 3 individual development types that are very frequently crop up in our casework. So specifically, that's extensions to buildings, replacement buildings, and limited infilling in villages. So that's what's in store. So let's start with the 6 broad steps, and yeah, you can see those on the screen. And these are the steps that we advise inspectors in training to take, or all inspectors to take, when considering Green Belt appeals. And just going through those one by one. So first question, is the development inappropriate or not? And then how should effects on openness and purposes be dealt with, or what would the effect be on openness and purposes, Green Belt purposes? Then look at any other issues. Would any other harm arise? These are sort of non-Green Belt factors, typically character and appearance, highway safety, and so on. And those are the issues, the other main issues in the appeal, often arising from the reasons for refusal. So consideration of the sort of normal, ordinary kind of issues that might arise in appeal. Then number 3 is thinking about the other considerations. So if the development is inappropriate or would be inappropriate, then what are the other considerations, and a review and examination of those, and some thoughts as to how much weight or importance to give them. I think it's worth saying that throughout this talk, we're going to assume that development is inappropriate. If it was not inappropriate, then it would be quite a short talk. So just bear that in mind as we go through it. So other considerations, number 3. 4th step, if those other considerations exist, in most cases there are some, then the question is, well, do they clearly outweigh the harm to the Green Belt and any other harm? And this is the Green Belt balancing exercise. 5thly, then, if other considerations do clearly outweigh the harm, do very special circumstances exist? I'll say a little bit more about the interplay of those 2 things later on. And then finally, reaching conclusions against the development plan, 38.6, development plan as a whole. So a final conclusion before the ultimate decision. So that's the structure that we recommend that inspectors adopt in their casework. And I think that's a helpful structure as well for local authorities and for developers, planning consultants, agents submitting appeals as well. And certainly it would be helpful to us if people did adopt a similar structure in their appeal statements. So that's a plea from us to help us. As you will have seen from all appeal decisions, the first thing that an inspector we'll do is to define the main issues, and this is standard for all our work. Why do we do this? Well, I think it brings focus to the matters in hand, and also it poses the questions that need to be answered, and that's no different in greenbelt cases to any other work. So that's what you'll see at the top of pretty well all of our decisions under Section 78, anyway. Then the next step, or the next step to look at, or the next part of the talk, is about inappropriate development. Is the development inappropriate or not? And clearly this is a fundamental question from which the rest of the decision flows. And if it is inappropriate development, then very special circumstances are required to be shown in order to allow the appeal. And as I said earlier, if not, if it's not inappropriate development, then it will just be dealt with as a normal non-greenbelt case. And what is now paras 154 and 155 of the framework set out national policy, and they provide quite a lot of detail, really, when in helping us to know whether something is inappropriate or not. And basically, development in the greenbelt is inappropriate unless it meets one of the exceptions, and those are defined in the framework. And we'll look at, as I've already indicated, a few of those in a bit more detail later on. So in deciding whether something's inappropriate or not, you've got national policy that gives us a very good guide, a very good steer, but also development plan policy may also be relevant. Not in every case, but in my experience, development plan policies do often give a local interpretation of certain things, such as whether an extension be disproportionate or not, or they might contain a local definition of what is inappropriate development. So there will be times when there's a conflict between national policy and local policy. If that is the case, then framework paragraph 232 comes into play, which talks about the consistency of the development plan with the framework. And all of this is all about deciding, how do you judge whether something's inappropriate or not? Do you rely on national policy, or do you need to use the local policy? And there's a judgment to be made about that. As far as I'm concerned, I mean, by and large, if there is a local interpretation of national policy which adds something, or which says how a certain word should be considered, I mean, that's a bit less problematic than policies that go in a completely different direction to the framework. So fly in the face of the framework, say something goes in an opposite direction, or which add additional criteria which are not part of the framework. Plans that have been examined in recent years obviously have to meet the tests of soundness and should be consistent with national policy in any event, but in older development plans that may not be the case. And I think in circumstances where the local plan policy is inconsistent with the framework, then it's more likely than not, I'm not going to speak for all inspectors, it's more likely than not that the inspector will rely on the framework definition as the basis for the decision, and the decision in terms of whether something's inappropriate or not, because, as I've indicated, the development plan policy is not consistent with the framework. So judgments to be made there, but just to explain that policies which go against national policy in the Greenbelt can be slightly problematic in terms of deciding how to assess inappropriate development. Okay, let's talk a bit more about something else. Let's talk about openness. So starting on this, draw attention to the PPG on the Greenbelt, which sets out the factors that can be taken into account when considering the potential impact of development on the openness of the Greenbelt. And three things are set out there, which are visual and spatial aspect, duration, and activity. And as far as we're concerned, that reflects the case law that's found in Turner, and also Samuel Smith Supreme Court judgment. As Rich said, I'm not going to give all the details of those cases, but they do appear in a slide at the very end of the presentation. So ultimately, the impact on openness, the effect on openness, it comes down to a matter of planning judgment. So something that's in the court of the inspector. And we encourage inspectors to think about all of these aspects highlighted in the PPG. I think of particular interest is the visual and spatial aspects of openness. And what exactly do they mean? We don't have any definition of that, but I'll give you my view for what it's worth. And I think that relates to, in terms of the spatial aspect, I think that relates to the scale of the intrusion into the green belt, the scale of the development. And then in terms of the visual aspect, I think it's whether the development, or how apparent the development is within its greenbelt context. Just to underline, that's my view of what those words, how those words could be considered. I think it's also important to stress that there doesn't need to be harm in both respects. There doesn't need to be harm caused in respect to both visual and spatial aspects in order for there to be an adverse impact on the green belt. So a large development might not have much or any visual impact, but still it might reasonably be said that it significantly reduces openness just because of its sheer size. Equally, a relatively small development might be more intrusive visually and therefore could also be said to cause significant harm, even if spatially the effect wouldn't be that great. I think it's also worth noting something from the Supreme Court judgment in Samuel Smith, which said that openness doesn't imply freedom from any sort of development. So I don't think it would be right to think that any new development into the green belt would automatically harm openness. Might be some effect on openness, but would there actually be any harm to it? And that comes down to a matter of judgment. And on a similar sort of theme, there's reference in paragraphs 154B and H of the framework to preserving openness. And here I think there's a judgment called Euro Garages, which helps us, which says that you shouldn't treat any change in the green belt as failing to preserve. So preserve is not an absolute term, but rather the question to be asked is, would the impact be harmful? I think that ties in with the Samuel Smith judgment I just mentioned. And whether it would or not depends on things that we've just been talking about, the scale of development, locational context, and the spatial or visual implications. And I think from our point of view anyway, the word preserve is sometimes interpreted as meaning, well, there can be no change at all. We don't think that's right, and Euro Garages supports that. Preserve has to be considered in the round, in the light of Samuel Smith, and an assessment made as to whether there would be harm to openness rather than any change at all. Another important principle relating to openness comes from a judgment, Lee Valley Regional Park Authority from 2016, Court of Appeal, which found that where a development is not inappropriate, then it should not be regarded as harmful either to the openness of the green belt or to the purposes of including land within it. So just to stress this, then, the case law is that a finding, so if you make a finding that the extension would be proportionate to the original building, using that as an example, and therefore not inappropriate development, so anything that's not inappropriate development, in those circumstances, the result of the case law means there will be no harm to openness or purposes. That's implicit in the finding that the development would not be inappropriate. And in those circumstances, there's no place for a subsequent assessment of openness. So the decision maker should not go on in a case where something's not inappropriate to then consider openness and purposes. That's not what should happen. Other considerations. That's our next topic. So here we're thinking about what are they and what weight or importance should be given to them. That's the way we encourage our inspectors to approach this sort of decisions in the Green Belt. And we know from the case law, there's a case in Brentwood, that there are no real restrictions on what can be another consideration. And in that particular case, it was said the list is endless. What is helpful to us when submitting an appeal and making a case to us is if those other considerations that weigh in favour are specifically identified and set out clearly, rather than them being implied. I think inspectors will consider the totality of any case made, but better still if they're set out clearly so we can understand exactly what they are. And similarly for local authorities, it's helpful to us to actually comment on those other considerations and to explain their view of them and the weight or the importance that they might attach to them in the overall balance. Of course, that weight is ultimately a matter for the inspector to decide upon, and elaborate exercises in saying what the weight should be, which we do come across, and prescribing the words that should be attached to particular considerations. Personally, I don't find particularly useful or helpful. What is useful or helpful is the evidence that supports that consideration and why it should be thought of as important in favour of a case or not. So rather than spend a lot of time devising a matrix or anything like that, then evidence to support contentions made is what's more useful to us. In support of other considerations, previous appeal decisions are often provided, and the real value of these is usually pretty limited in my view. And we have from Lord Justice Holgate in the Vistry Homes Fairfax acquisitions judgment this quote, which I put in support of what I'm saying. So little help can be gained from looking at the decisions of inspectors on other appeals. This was in the context of the weight to be given to benefits in favour of a scheme. It wasn't in the Green Belt, but I think similar principles apply. And Lord Justice Holgate gave his reasons for that, which are set out on the quote on the screen. And yeah, you can see it for yourself, but varying terms are used, and we don't often know why a particular weighting was adopted. So just because an inspector gives significant weight to a particular factor in an appeal elsewhere, such as, I don't know, better design of the scheme or some improvement to openness, just because that was the case in one appeal, doesn't automatically mean that significant weight or the similar amount of weight should be given to that point in the case that's before the inspector in the appeal that you're dealing with. So I think my plea is, and I think it's a plea from all inspectors as well, is to think very carefully about providing us with a great sheaf of appeal decisions which purport to show that a certain amount of weight should be given to a particular consideration. In general terms, not particularly helpful. Inspectors will have to consider those and grapple with them. But in my experience, it usually doesn't take the case forward from anybody, either one way or the other. One other consideration that's often put forward is the fallback position, which is what might be done on the land without a grant of planning permission if the proposed development doesn't go ahead. I'm not going to go into the relevant case law here. Perhaps that's the subject of another webinar. But my summary of it is that it involves considering whether there is a greater than theoretical possibility that the alternative development might take place, and if so, the weight that should be given to that. But I think for purposes of today, it points to stress are that if you are making arguments about fallback, then it's really helpful if that's clearly defined. So what is it exactly that's being argued that would ensue if the development wouldn't take place? And to underline that there's no duty on an inspector to consider hypothetical positions that haven't been put forward. So you wouldn't expect the inspector to root around and consider what sort of, for example, permitted development rights exist if those have not been highlighted. And in relation to permitted development, I think I would say it's very helpful if it could be explained why it's being said that a particular form of development would be permitted development or not. So having regard to the GPDO, so why is it you say that something would be permitted development or not? This isn't obviously the only type of fallback position, but in my experience, detail of what might lawfully proceed is often not covered in particular detail, and the inspector is left slightly adrift, wondering how to deal with that particular point. So some detail there would be helpful to us. And final thing to say about this is that if part of the case being put forward is that an existing building would be removed, then it's important to give consideration to what provisions are in place to secure this at an appropriate time. And that point, I think, applies both to people putting forward schemes and local authorities in considering them. And again, from experience, that's something that's often not considered by the parties. So very special circumstances. Final thing of this sort of first bit. So the first point to make is please be sure that you use the right words and apply the test correctly. So the other considerations need to clearly, underline that word, outweigh the potential harm to the green belt by reason of inappropriateness and any other harm. And that's non-green belt harm. So just a plea to be sure that those words are applied accurately as stated in the framework. And the framework, as we know, indicates that substantial weight should be given to any harm to the green belt. It's paragraph 153. And now, following the recent changes, that makes specific reference to harm to its openness. And the way that inspectors are advised to deal with other considerations and very special circumstances is to review the other considerations first, and then balance those against all of the harms and decide whether they would clearly outweigh them or not. If they find that they do clearly outweigh, then take a step back and consider whether very special circumstances exist. A few points about very special circumstances. The first one is that the other considerations do not have to be very special in themselves. So the other considerations, don't think of those in terms of whether they each amount to very special circumstances. The very special circumstances test comes at the very end once you've considered all of those other considerations. It may be that a series of small positive other considerations may all add up and may clearly outweigh the totality of harm. And the case law also indicates that other considerations don't have to be rare, uncommon, or unique in order to attract weight. But it may be relevant if the claimed advantages of a scheme could be achieved by other means. And the approach to be taken in this greenbelt balance part of any decision was considered in a judgment in Sefton 2001. And there it was alleged that the inspector should have applied substantial weight to each of the greenbelt harms identified. But it was found there was no error in not doing that, in not attaching separate substantial weight to each element of harm. So the case was being made that the inspector should have given substantial weight to the harm by reason of inappropriate development, substantial weight to the harm to openness, and substantial weight to the harm to purposes. And the court said, no, didn't need to do that, and you didn't need to attach substantial weight to each of those harms individually. So long as you gave substantial weight to the totality of greenbelt harm, that was all that was required in law. Well, that's our interpretation of it anyway. And here's a quote from the judge saying that, well, it's not a mathematical exercise. That goes back to what I was saying about matrices and the like. It is a question of judgment, and it's a single judgment to simply assess whether there are very special circumstances. We advise inspectors to sort of go about it in a logical, sequential way, but ultimately, the courts have helped us, I think, by saying, yeah, it is just a matter of judgment. So really, there's no magic formula as to how these things are decided. I think that's the point I wanted to get across. And as Rich was saying, there's no instructions to inspectors to how they should be decided. The considerations will all be different depending on the scale of the development. But I think the principles that I've outlined will apply in every greenbelt case. All right, let's move on then and consider some of the individual development types that can be exceptions under 154 and 155. And as I said earlier, these are relatively small scale, but they probably make up the biggest bulk of our work in greenbelt cases. So firstly, extensions to the original building, and the test is essentially whether they're disproportionate or not. Paragraph 154C of the framework applies. So here, a judgment or decision has to be made on the basis of any cumulative additions to the building concerned. And in cases like this, if there have been previous extensions to a building, then it's really, really helpful if that is detailed, figures given, accurate figures given, and even better still if those can be agreed between the parties and any differences highlighted. Again, that just assists an inspector to get to the main focus of the disagreement rather than having to spend time working out whether there's an accurate calculation or not. And whether an extension is disproportionate or not is, in our view, primarily an objective exercise relating to size, and that might be assessed by means of floor space, footprint, or volume, or perhaps a combination of all three. And as I mentioned earlier, local policies defining a percentage will also be relevant. I think those policies are perhaps rather a blunt tool to use to decide this point, but nevertheless, on the other hand, they will provide some certainty. But the main thing is, given the status of the development plan, they can't be ignored. Any assessment shouldn't consider the effect on openness. But in terms of the role of visual impact here, I mean, I've said that it's primarily an objective exercise relating to size, but visual impact, haven't come across any specific case law on this point in relation to disproportionate extensions, but I'm going to talk in a minute about the Heath and Hampstead case and the test, which was to do with the replacement dwelling. That's a different test than the framework, but I think it's reasonable that some of those principles are relevant to this form of development. And what we would think would put forward is that, well, in a marginal case and absent a relevant development plan policy, visual impact may have a part to play. It's not the primary thing, but it may have a part to play. And that seems logical in as much as a sprawling extension might well give rise to a finding that it's disproportionate compared to one that's exactly the same size, but is less bulky. So I think that would be our general approach to that question. There is often disagreement in appeals about what is the original building. That is, so what's the starting point for this assessment? That is defined in the framework, and inspectors will use that definition unless there is a local development plan policy that says something different. And so that definition is a building as it existed on 1st July 1948, or if constructed after 1st July 1948, as it was built originally. The assessment at this point should be against the building that exists now, and not one that could be extended or following extensions that might be done on permitted development or even extant permissions. So it's what's on site now that is the starting point. But of course, those matters might well be relevant, or are likely to be relevant as other considerations. A thorny issue can arise in relation to replacement dwellings. So there was a dwelling on the house, it's the dwelling on the site rather originally, it's replaced, and then proposals are made to extend it. So in our view, the national definition relates to the current building on the site as built originally, rather than some previous building which has long since been demolished. So that might well mean that the replacement dwelling is the starting point for any assessment. And I understand that local authorities are often concerned about the cumulative impact of this. So the dwelling was replaced with something slightly larger, and then further proposals to extend it further. But in the absence of any development plan policies dealing with this matter, then inspectors will simply use the framework definition to decide the point. And I've indicated that our view is that doesn't require reversion to the original building on the dwelling on the site. There was a recent case, fairly recent case in Guildford that sort of looked at this question, but in that instance there was a specific local plan policy which set out how original building was to be interpreted, and that policy should have taken the inspector back to the very first building on the site pre-1948. The inspector's decision was quashed, but that was because the policy was misinterpreted. And so in our view, this judgment doesn't indicate anything different to what I've been saying, because it was solely concerned with a local plan policy which wasn't applied correctly. It's also worth noting that removing permitted development rights by condition on a replacement dwelling doesn't automatically prevent future extensions. Rather, it brings them under control. The circumstances of the case or the planning history, I think, will be relevant in sort of cases where there are conditions or applications made to remove those conditions. But I think it's a relevant fact that there are permitted development rights are no different in the Greenbelt to anywhere else. What is an extension? Might seem an obvious thing to question or obvious thing to answer. The framework obviously makes no mention of curtilage buildings. There might be relevant development plan policies that cover this and how they're to be dealt with. But if there aren't, then the framework again is what inspectors would fall back on. There is, however, a judgment I just wanted to draw attention to, Warwick judgment, where the judge was dealing with the framework in relation to this matter, and he said, well, no, it isn't to be interpreted. The word addition is not to be interpreted as being confined to physically attached structures, but it can include things that are detached from the main building. So I think as a result of that, it would be, well, unlawful, I think, to find that an outbuilding shouldn't be treated as an extension for the purposes of the framework, paragraph 154C, solely on the basis it was not linked to another building. Whether a detached structure would amount to an extension of the existing building would, I think, be a matter of fact and degree. For residential outbuildings, it seems to me it would be reasonable to take into account whether the proposal was to use words from an earlier judgment in Sevenoaks and Door, whether the proposal was a normal domestic adjunct. And I think in our view, you'd be considering whether what the purpose and use of the proposed building was, its relationship with the original building, and its size and other relevant factors. All right, the next topic I was going to look at, or type of development going to look at, was replacement buildings. So paragraph 154D of the framework. Two questions really: is the building in the same use, and would it be materially larger? I'm just going to talk about the latter. And I've already mentioned the Heath and Hampstead judgments from 2007 of the High Court and the subsequent Court of Appeal judgment. And that came up with the expression that it was primarily an objective exercise in deciding whether something's materially larger, an objective exercise by reference to size, and highlighted different sorts of physical dimensions that might be used. The High Court judgment said that this wasn't solely a mathematical comparison, but equally it was not a decision about whether the proposal would be more visually intrusive. And if an increase in the dimensions was marginal, then some regard may be had to matters such as bulk, height, mass, and prominence. In the Heath and Hampstead case, the replacement dwelling was, depending on how it was measured, was at least double the size of the original one. So it clearly was materially larger in mathematical terms, but the judge took the view that the fact that it was fairly discreetly positioned, couldn't overcome the fact that when considered against the actual words of the framework as it then, or the national policies it then was, that it would be materially larger. So in considering this, I think it's mainly to do with size, and that the visual impact can come into play if there's a marginal decision to be made about the numerical comparison. The decision maker's role is to consider whether the replacement building would be materially larger than the existing building to be replaced. So that's the baseline. There was a case called Athlone House that considered this, and 2 points arising: that whether it is materially large or not is a question of fact and degree, that before, and also that the unimplemented permission wouldn't count as part of the baseline. And two more cases to highlight. There's a Tandridge case whereby it was lawful for a larger single building to replace a small number of existing buildings, plural, provided as a matter of judgment they could sensibly be considered together compared to what is proposed to replace them. So was looking at the issue of whether it mattered that the national policy was in the singular and there were more than one building, and basically said no, it doesn't, provided there is some clear linkage between the two. And also in a case called Feather, it was deemed that it was reasonable to take account of abasement in deciding whether a replacement was materially larger or not. And finally, I'm just going to look at briefly limited infilling in villages. 3 questions to be posed here. Is the site within the village? Is the development proposed limited? And is it infilling? So there are no definitions of any of this in national policy. Some development plan policies do contain them, but essentially deciding these points will be a question of fact and planning judgment again for the decision maker. And in a case called Tate, that talked about things like that judgment would be concerned with the nature and size of the development, location of the application site, and its relationship to other existing development adjoining and adjacent to it. I also want to highlight another important case in which to do with whether a site was within a village or not. And this is the Julian Wood case, 2015. And this determined that the boundary of a village defined in a local plan, settlement boundary, is not necessarily determinative for this purpose. The inspector thought that it was. The court said that it wasn't. So when considering whether a settlement is a village or whether a site is in a village, our advice to inspectors is that they should have regard to the situation on the ground in addition to any relevant policies. A judgment needs to be made, but that's likely to depend on a number of factors, such as the number of buildings or properties grouped together, the interrelationship and spacing, facilities and services available, and the juxtaposition of the site with surrounding buildings and any open land beyond. But I think the key point is the local plan policy about settlement boundaries isn't the be-all and end-all in deciding whether a site's within a village. And you can see now we've got up all of the cases that I've been mentioning, so they're there for your reference. As Rich said, please do check those out for yourself before you rely upon them. Although we've done our best to be sure that we're referring to them in the right way. And I think I'm going to hand over to Rich now, who's going to lead us through any questions and our responses to them, and a few final housekeeping points, I think. So thank you for your attention.
Yeah, brilliant. Thanks, David. That was excellent, as always. I should say one of those cases listed, the Tandridge one, was one of mine, and we won. So feel free to look at that as a bit of a highlight. We do have, well, we've overrun a bit, I'm afraid, but we will deal with some questions and we'll happily carry on for a little bit if people have got the time to stay. So the first one, I mean, you've touched on this one, David. I will say the approach I'll take to these questions is to look at the ones that have got the most upvotes on them. So the first one's from Kirsty Elliott. What is your view on local policy that seeks to set percentage limits in terms of what is a disproportionate addition? Now, you and I have had some debate about this in advance, but and you touched on it briefly in relation to that, and indeed replacement dwellings. But do you have anything more to add at this point, or are you happy with what you've said so far?
No, I think it's. I mean, they exist. I mean, they provide certainty, as I said. I think in terms of defining it. I mean, how you come up with a particular percentage figure and justify that through a local plan examination, I think, is another thing. But equally, it can lead to some slightly perverse results, I think, to be honest, whereby your limit is 40% and something that's 41% is deemed to be disproportionate and therefore inappropriate development. So yeah, I don't know. Does that help, Rich, or not? Anything you want to add?
Well, yeah. I mean, there are. What am I trying to say? I think it depends very much on a local context, and I think those crafting such policies need to think carefully about what it is they're trying to achieve in relation to them and the nature of the development in their area. You know, to what extent does how much I say? To what extent, as David said, would it lead to a reverse consequence or an outcome that actually, if the dwelling in question or the building in question wasn't in the green belt, actually, would you perhaps allow what's being proposed rather than dismiss it on the basis of potentially a bit of a finger in the wind percentage figure? So, yeah, I mean, as David said, there's mixed views on this. They do provide certainty for everybody, but then the flip side is that it takes away a degree of judgment and means that you can't necessarily apply the context of the site and take that into account when it comes to making the call. And it can, from some inspectors, find it frustrating having to do endless number crunching in relation to X% of the volume Y is what. So yeah, let's just say that horses for courses, I suspect, is probably the best way to put that. Next one with the most votes. I'm not sure necessarily we can answer this, to be honest, because it's to do with grey belt, I think. How is strongly to be interpreted in relation to green belt purposes in a current appeal? I have a view on that, but do you want to kick off, David, or not?
Thanks, Rich, very much.
Hospital pass this.
Yes, I know. Yeah,
do you want me to take it? I'm happy to take
nothing,
it. If you
nothing less than what I was expecting. Well, the words are the words, aren't they? And I think we will be getting into that when we as time goes by. And the word strongly does have a meaning. But I mean, and I think the point is we won't be telling inspectors it means this or this is what you do in that circumstances. It will all depend upon the nature of the case and such like. And I mean, strongly, I suppose, does imply it's quite a high bar. But I don't think there's much more to be said than that really, Rich.
Yeah, no, I'd agree. I think it's going to be a judgment call, and the specific nature of the case is going to have a bearing. As I say, as David said, we're not really into that yet, insofar as the grey belt sort of issue hasn't really sort of kicked into play. So yeah, I'm not sure we can say an awful lot more, to be honest. Excuse me. Let's have a look. Where are we? So we've had that. We've had that. The next one, Alex Walker Robson. Would affordable housing still be afforded weight in a case for very special circumstances if, for example, it accords with a development plan, e.g. 35%, but not according with the golden rules, i.e. 50%? My view would, well, okay. Do you understand that? It's easier for me so I can read it, David, but do you get what's being driven at there?
Yeah, I mean, affordable housing, if that is part of the scheme, then as another consideration, then yes, you would give it weight. If it's simply policy compliant for that authority, then my view is that you would still give it weight. And I think that's one of the points that arose from the Vistry Homes judgment, that a benefit, just because it's policy compliant doesn't mean to say that you kind of ignore it or just say it's policy compliant and therefore it's limited weight. You'd look at the wider context. The golden rules, as I understand it, apply only to major development in the green belt, so depend on the scale of what was being proposed. So yeah, I think affordable housing would be another consideration you give weight to, but how much you give it will depend exactly upon all the circumstances of the case.
Yeah, agreed. To be honest, that's what I was going to say. So,
I
mean, let's be clear. I mean, obviously, the golden rule exists for a purpose, and that's the sort of government expectation in relation to those cases. But as David says, yeah, well, I agree with what David says on that. So, suppose the second one is a similar one. I'm not sure, or the next one that I'm not sure we can necessarily get into in particular detail. Will the inspectorate place a high bar on the new paragraph 154G requirement relating to substantial harm to openness in a similar way to Caselaw and decisions in relation to heritage assets? Are we looking at a test or bar of harm that calls into question the inclusion of the site in the green belt when assessed against the 5 purposes? No, I don't think so. But again, do you understand where that's coming from, David, without being able to read it?
Yeah. Yes. No. I can't see these questions, so
No, exactly.
I'm relying on you, Rich.
Yeah.
Well, I mean, substantial. Well, firstly, in any appeal decision, we're not going to challenge whether a site is rightly included in the green belt or not. That's not the purpose. If it's in the green belt, it's in the green belt, and we proceed on that basis.
Yeah.
Substantial harm is from memory is not. It's not new. That's not new. So we would carry on doing what we were doing before in relation to the substantial harm. And again, it's like these words, isn't it? Strongly. What does that mean? Substantial harm. Well, it's got to be quite a lot. I think it's not just harm. It's something over and above that. So I think that would be my sort of common sense interpretation of the words. And I'm not convinced that that's a change that is going to make an awful lot of difference to the way that things were done before.
Yeah, I mean that's my feel, to be honest. Yeah, okay, I'm not sure. Yeah, I mean the sort of again, I'm not sure. Well, this is going to be another fact and degree one, and not necessarily. So PDL, then obviously we've got the new glossary in relation to PDL talks about lawfully developed land. Obviously PDL can fall within one of the greenbelt exceptions, so the least only question. Does that mean that land developed unlawfully is now not PDL? Or if such land is developed unlawfully, can it be considered so after the immunity period for enforcement action has passed? I'm not sure we can say much about that, if I'm honest, but in relation to fact and degree and so forth. But go on, David.
Yeah, I think, I mean, to me that this is relatively self-evident. I mean, I think.
Well, that's what I meant.
I don't put myself in the mind of government necessarily, but I think this is there to kind of deal with land where unauthorized development has taken place, and saying, well, if it's unauthorized, then you can't claim it's previously developed land. I think that's to kind of close off a potential loophole. And so it is what it is. You might be arguments about whether the land has been lawfully developed or not, but that's a matter to be decided on the individual case. Yeah. But if it's shown that development, has become immune from enforcement, then it becomes lawful, and then it might well be counted as previously developed land. So again, depends on the exact arguments and what's there and what the position is and how long has it been there and so on and so forth. But yeah, I think that's relatively straightforward.
Yeah, I agree. I mean, the intent is very clear, and as David says, I think the finer points of argument are down to the individual case, to be honest, in relation to enforcement and so forth. But yeah, I think in terms of read on its face, it's fairly clear. Okay, let me just. So I think am I refreshing properly? Let me just see. Yep, had that. I don't think they are. So James is a procedural question. Okay, Rhys Graham. To what extent is special circumstances applied in the context of major infrastructure projects in the Greenbelt, i.e., where local policies may take an inappropriate stance, but the NPPF may be open to more open to interpretation? I assume that's not talking about NSIP. I'm sure that's talking about straightforward Section 78 appeals. In which case, well, again, I think it's going to come down to a judgment call. But David, you.
Well, yeah, I mean, firstly, it's very special circumstances, not just special circumstances. Sorry to
No,
pick up on being pedantic about that, but the words are important in Greenbelt case law, as they are in many others, but particularly in Greenbelt. I mean, clearly, if the framework in national policy talks about giving weight or importance to sort of infrastructure of different types or any form of development come to that, then that clearly is going to have a bearing on the weighting of the other considerations. So can't think of an example off the top of my head, but that's a sort of general point. And again, then it all comes down to the balance to be made, doesn't it, between the level of harm that might be caused by development against the benefits that would flow from it. I mean, I think the examples I talked about in detail are sort of fairly small scale. If you're dealing with a more major development, infrastructure, commercial development, housing, then the balancing becomes more is a different sort of balancing, if you like. You've got bigger factors at play, and what it says in national policy might also have a bearing in terms of boosting housing supply and all that sort of thing. But the principles that we outlined, I think, hold good in any case that you might deal with in the green belt. So yeah, I'm not sure, again, much more to be said about that, because it all comes down to the beauty of the individual case and the evidence that's before the inspector.
Yeah, agreed. Just a bit of a minor tangent, just the point that David was making in his presentation. I just want to re-emphasize this because it is a bugbear of many inspectors. If you know, and indeed I made reference to this in the most recent decision that I determined, having step myself back into the field briefly, is other appeal decisions are rarely of any use at all to us, unless you've got a almost identical proposal that you think is relevant. But please think very carefully before you waft appeal decisions under inspectors' noses. It just adds time and effort to the whole proceedings, and there's rarely anything to be gained, to be honest, from them. So I just wanted to reiterate that. And you can usually find, if you present decisions saying one thing, the other side will present a whole bunch saying something completely different, which just goes to show that it's all a matter of judgment at the end of the day. So anyway, apologies, minor rant there. So maybe we'll just take a couple more. Again, this is going to be a kind of how long's a piece of string, but from your experience, how much weight is normally given to the public benefits of proposed developments, such as affordable housing, renewable energy, when deciding greenbelt appeals? From Ankit, this one. Yeah, I thought exactly.
I think we probably covered that as best as we can,
so. Yeah.
or already.
Yeah, I think so. It's going to come down to, as David said before, the individual aspects of the case, and what the entirety of the argument around the package of very special circumstances is being argued as being. So I wouldn't have said any attracts more or less specifically. Next one, again a bit general. What are inspectors' views on removing permitted development rights through conditions? I mean, again, we couldn't. Well, the views of all inspectors. Well, again, at the risk of stating the bleeding obvious, it depends what it is you're hoping to achieve, really, and certainly the advice we provide to inspectors is don't do it unless there is a very particular issue that requires addressing. But again, David, I don't know if you want to come in.
Yes, I think I did sort of allude to this, and yes, I mean, there's nothing different about the greenbelt compared to anywhere else. Can you justify the removal of permitted development rights having regard to what it says in national policy and guidance? I understand why it's done, and in terms of coming to, so I suppose Rich's point is one I would endorse. Don't do it unthinkingly. Think about the purpose of it, what you're trying to achieve, and whether it's necessary. That's one of the tests. So yeah, I think that's the only plea I would make. Can I just, Rich? I've seen a question here.
Yeah, go for it.
From David Smith, which was
I see that as well. I assumed you hadn't posted
and
yourself.
And it's talking about considering harms. Do inspectors value the use of CGIs to illustrate the likely impact of schemes? or the potential impact by reference to wire lines and frames. And I was going to say, yeah, I mean, CGI is always useful. It's really helpful. I mean, I've got an imagination uh, of what a scheme's going to look like, but I generally find that CGI showing it are really helpful. So if there's an opportunity to provide that, I appreciate there's a cost implication in producing these things, but yeah, visual demonstrate. I mean, was it a picture paints 1,000 words and all that sort of thing, and it really is true. So yeah, I would say that is helpful.
Yeah, I just endorse that. And we are at the inspectorate seeing this increasingly in all sorts of appeals, and it can be, as long as there's agreement, I suppose, between the parties that what's being portrayed is accurate, then it can be extremely helpful. Certainly, we have had inspectors on site being presented with goggles to look at stuff, as well as the classic fly through in an inquiry situation. So yes, it is useful, albeit with the usual caveats around AI creations and so forth. Maybe that's yeah. Okay, numbers have not dropped off dramatically, so maybe we'll take another. Well, so I'm just assuming happily, David, that you haven't got somewhere to dash off to, which you may well do. In which,
I've got
the
to go
one.
and finish some appeal decisions, Rich.
Well, that's true. All right, I tell you what, we'll 5 more minutes and then we'll call it a day. So the one, this one's interesting actually. So we will just touch on this. There's new footnote 55 in relation to para 153, which is to do with PDL. Now mean development can be appropriate, but still require an assessment of openness, contrary to the Lee Valley decision. Now, I will be frank here and say that David and I have talked about this in anticipation of this question arising. I'm happy to deal with it. Well, to the extent to say that I'm not sure we can, if I'm honest. We we are aware that this is an issue, as are our colleagues at MHCLG. What happens next, I think, is probably not for us to say, to be honest. But so Will Hossack, yeah, we probably can't answer that question, I'm afraid. But it doesn't, it is a conundrum with which we are well aware. Um, quick one is C2 accommodation required to deliver the contributions listed in the golden rules, e.g. affordable housing. I don't see why it wouldn't be, I suppose, is my honest answer. David, I mean, there's nothing to say it's not. So
No, I don't think I've
yeah,
got anything to add to that.
no, exactly. Yeah. So I would say yes, pending the usual caveats around, viability considerations and so on and so forth. But again, the golden rules are the golden rules, and I don't see any C2 exception there. I think the rest are probably okay. Really, are there certain considerations that should be given more uniform, no, more uniform weight in terms of what's the approach to them, such as 10% biodiversity net gain, the ministerial statement on greenbelt, very special circumstances from March 2015, albeit well, that's a quite significant vintage now. But I mean, this is a broader point, really, isn't it? I think, which again, I think David, you touched on about individual allocations of weight. But do you have a general observation to make on that?
Yeah, I mean, it's kind of interesting. I mean, I've said that weighting is very much a matter of the individual decision maker and so on and so forth. But I mean, to some extent, it would make life a lot easier if there was a kind of a broad national agreement to say, well, yeah, this matter has so much weight, and that applies in all cases. I suppose that the difficulty is that it's all a question of scale, isn't it? So, we know we give, if there's a shortfall in the housing supply and housing is proposed, then you give weight to the additional houses that are proposed, but you probably give a bit more weight to them if there's 30 houses as opposed to 3. So I think that's the difficulty there. But the sort of universal application of weight would lead to perhaps more consistent decision making, but it would take away the discretionary judgment that we have now.
Yeah.
And sorry, Rich, there's a question here from
Awesome.
Neil Holdsworth. Hello, Neil, if you're still there listening. Um, and talking about some published guidance on how to evidence the fallback position. So, Rich, maybe that's another webinar to talk about fallback.
Yeah. Yeah, very happy to. Yeah, again, it crops up as a regular issue, not just in Greenbelt by any means. So yeah, okay, yeah, we can certainly deal with that. So there's two on weight and consistency, yeah, which I think we've dealt with.
Oh,
Sorry, John.
here's a cracker from Stephen Bainbridge. What is weightier, great, substantial, or significant? Um, is it acceptable for a proponent to advance their own rationale, or are inspectors working off a hierarchy? So, I'll go first, and you can come
All
in
right,
afterwards.
go on then.
But no, we don't have a formal hierarchy. We don't instruct inspectors to use certain words to describe weight. Clearly, we have national policy talks about weight and describes it in different ways. I think that crops up about a dozen times or something like that. So we don't prescribe it. And yes, appellants often do put forward their own weighting that they suggest. I said in the talk, I don't personally find that particularly helpful, and I'd rather they explain, why a factor is significant and important rather than tell me, go into great detail about the weight. And remember the Sefton judgment, it's not a mathematical exercise. Of the words that were given, there was a judgment whereby the courts held that the words, this was a judgment case called Ward, which is a traveller site in the Green Belt, and the judge essentially said that the words substantial and significant were synonymous. So the courts in that particular case, and it was specific to the circumstances of the case, didn't draw a great distinction between the two words. I don't want to get in semantics here. You have your own view of that. But to me, there is a difference, and if I'm giving weight to something, I choose my words very carefully, as I'm sure all inspectors do. And if it's something that I think is very important, I'll try and express it in those terms. So I'm not going to give a specific answer to which is weightier, great, substantial, or significant in this forum. And I suppose the main thing is that when a decision is made, it's important to just give an indication of, is it of little importance or a great deal of importance? And that's the main thing, isn't it, really, rather than getting too bogged down in the detail wording. But it's an interesting kind of debate, isn't it?
Yeah.
Which we've had.
which we have indeed had. Yes. Yes, get inspectors around a table, particularly folk like David and I, who are interested in these sort of levels of detail, and you will get some interesting discussions and debates. But yeah, I mean, I agree with David. It would be helpful, but I don't think at the end of the day it's really, it would actually move the debate on much further, to be honest. And I think David's point about how important is something is what it fundamentally boils down to be honest. And then your words need to reflect that. So we've overrun by 16 minutes. It's dropped down to a mere 390 people now. So I think we will stop. Thank you all very much indeed for your time. I'm sorry to those of you whose questions we haven't managed to reach. Please do complete the webinar evaluation form that you'll get. I know it can be a bit of a pain, but it does help us very much. Thank you. We do read all of the feedback, and it helps us to plot for the future. So our next webinar, for those of you who are engaged with NSIP work, is hopefully going to be on linear schemes on a date in February. If you keep an eye on our socials, then it will be flagged up at that point. I think that's all I want to say. So thank you very much, David, for everything you've done today, and to our comms colleagues, Sarah North and Pete Bond, who've facilitated everything, and without whom we certainly couldn't have run this, and to all of you for attending. I hope it's been helpful, and we'll see you again soon. So have a good weekend, and look after yourselves.
Thanks, everybody. Cheerio.